Hello, everyone. My name is Sally, and I'm going to be speaking about sexual harassment cases in workplace. I'm going to share my screen. Gender in the workplace has been a topic of interest in the research world for many years. It contributes to discrimination, abuse of power, and sexual harassment of mostly women and LGBTQ community. I present the cases of victims of sexual harassment in workplaces. It questions how differences in gender impact the environment, layoffs, and relationships between the employees and employers. The presentation is aimed to understand the ways the people of color and gender are treated and how it is different from other ethnic and sex groups. I emphasize the understanding of the issue of gender inequality, specifically sexual harassment in workplace in the United States only. I want to give you an information about the first harassment laws, the history of American legislation regarding sexual harassment cases in workplace, the role of gender in litigating cases, and the problem of sexism mingled with racism within the Black community. Therefore, I state the following question. Is judicial policy about sexual harassment cases meaningfully adjudicated in the United States? The research is conducted by the application of a content analysis. It involves the collecting data from a set of written, oral, or visual texts like books, newspapers, magazines, interviews, social video articles, etc. I use qualitative content analysis for the study, specifically qualitative quoting, that enabled me to locate and gather the data in order to understand the intentions of individuals, groups, or institutions regarding the issue of sexual harassment cases in workplace. I use 2 peer review articles as my primary data and 5 secondary ones. I selected the method because it could have been very hard to interviewing individuals in this time of pandemic. My primary data number 1. The American history has some class action cases regarding the issue of sexual harassment. The Oscar-nominating movie, The North Country, deals with the famous Jansen 11th case, outlining particular challenges that poor white women have had in litigating cases of sexual harassment. I selected this case as my primary data to do the research. Powerless women, led by Jansen, joined together to demand change that later affected the lives of so many women workers. Although the North Country story did not end sexual harassment in workplace, it bore fruit as the employers were obligated to pay for their failure to meet women's complaints responsibly. Primary data number 2. The latest scandalous sexual harassment case related to Harvey Weinstein, a famous Hollywood producer, led to the whole movement called Me Too, when women and some men across the United States stepped out to share the experiences of sexual harassment. This is my second primary data I used for my research. Weinstein had engaged in sexual harassment and unwanted touching with female employees and other women seeking film roles or to begin or further a Hollywood career. The response was damning and swift. Even though Weinstein's exposure was a breakthrough for American and international community regarding sexual harassment in workplaces, the legal system in the nation still does not address the crime effectively. Many experts in legal world admit that it is narrow victory and it will take long to stop sexual predation at work. However, Weinstein's verdict could be a sign that our justice system is ready to accept stories of sexual harassment and abuse. Secondary data number 1. The history of American legislation regarding sexual harassment dates back to 1964, when sexual harassment got considered a form of sex discrimination by Title VII of the Civil Rights Act of 1964. Later, McKinnon and other white middle-class women played a vital role in the development of sexual harassment policy in the United States. As a result, the Civil Rights Act of 1991 was passed to regulate sexual harassment laws in the nation. In order to explain the law of sexual harassment, first the emphasis has to be done on the fact that there is no federal statute banning or addressing sexual harassment in workplace. When Title VII of Civil Rights Act of 1964 was enacted, Congress did not study that prohibition of the statute would lead employees who were the victims of sexual assaults to defend their rights in court. Secondary data number 2. Sexual harassment in workplace in the United States has been very common for decades. Traditionally, women were the objects of sexual discrimination in the 1970s, a great number of women re-entered the workforce, demanding fair and equal treatment from the supervisors and co-workers. The passing of a sexual harassment law in 1970s was an important step forward in the protection of women in the American workforce, especially non-conventional branches. For centuries, women in the United States had been sexually exploited before the law of sex discrimination was passed, restraining the existing traditional form. It was only in the late 1970s when feminist scholars and lawyers started to create a new, bold jurisprudence under Title VII of the Civil Rights Act of 1964. However, the gender of victims has changed in recent years. Secondary data number 3. Women of color is another group of victims of sexual harassment in workplace. In this case, the issue of sexism is mingled with racism within the Black community. It is a sad story of African American women who were victims of sexism and racism more than their white counterparts. Historically, during slavery, Black women were under sexual injustices when they were abused by the white slave masters. Therefore, the emancipation of Black women from sexism must be a part of the struggle of Blacks to liberate themselves from racism. The early sexual harassment cases did not rule that it was sex discrimination, as they did not consider sexual harassment gender-based. Moreover, federal courts believe that if they treated sexual harassment as sex discrimination, it would overwhelm courts with lawsuits for every sexual indiscretion in the workplace. Only McKinnon, first sexual harassment law made, only McKinnon's first sexual harassment law made it possible to change the treatment of the cases, declaring sexual harassment as sex discrimination. Secondary data number 4. Nowadays, LGBTQ community members have become the target for perpetrators. According to the recent statistics, even though there is a 21% decline in sexual harassment complaints in workplaces, there is an increase in complaints by males. Experts claim that the lives of victims are destroyed, bringing barriers to their career success and satisfaction. Consequently, there was a necessity to make some changes in the legislation regarding sexual harassment. The EEOC had to update the legal definition, including same-sex sexual harassment. Not only women, but LGBTQ individuals face the sexual discrimination in workplaces. Secondary data number 5. The nation was shocked when, first time in American history, a Black woman accused a politician of sexual harassment. It was Anita Hill, the one who gave the Senate a testimony about her allegations of sexual harassment by Supreme Court nominee Clarence Thomas. Nevertheless, the ruling of the case was not the favor of hers. It contributed a lot the decision of the Congress during George Bush presidency to pass the bill giving harassment victims the right to seek federal damage award back pay, and reinstatement. As a result, a number of sexual harassment cases filed with EEOC as well as in the federal and state courts has increased dramatically. In just 1 year after the Anita Hill Thomas clearance hearings, the number of sexual harassment cases jumped 50% across the nation. Key findings. Judicial policy regarding sexual harassment in workplace is not meaningfully adjudicated in the United States. Even though the situation is much better today regarding the issue compared to the past decades, when first in 1964, then in 1970s, and finally in 1991, several significant legislations were enacted, still legal institutions like courts need to be reformed in this direction. Women and LGBTQ community are the most vulnerable groups who are mostly the victims of sexual discrimination. The issue of gender, specifically regarding sexual harassment, is not equal in our society, and number of litigating cases are related to it. Legal institutions should alter their approaches to sexual harassment cases. For instance, courts should change the practice of cross examination of the sexual harassment survivors, as today their questioning causes the victims a lot of trauma. Instead, cross examination of the victims must be conducted in the environment where they will be free of stress and any pressure from prosecutors and judges. As EEOC states, our legal system has come far away, but to our dismay, we still have far to go. Thank you very much.